warm welcome. This is our panel on the EU common data spaces. And during today's discussion, we will focus on Europe's bid to increase its competitiveness, to boost innovation, and to increase the value that we get from public data, and how Europe intends to become more independent, competitive, and sovereign on the world scale. In this context, the idea of leveraging data to boost all of these aspects has become critical in Europe and has gained a lot of traction in policy circles. But as we go deeper into this debate, there are some questions that we have to ask ourselves. First of all, if we discuss innovation, innovation for whom? If we discuss competition, competition under what conditions? And if we discuss fundamental rights, what costs are there to fundamental rights? So for today's debate, I'd like you to keep in mind three keywords: innovation, competition, and fundamental rights. My name is Georgiana Mirza, and I'm a researcher at ALTI and VU Amsterdam. And I'm really pleased today to welcome our panel of speakers who are all outstanding experts, and who, might I add, have very different perspectives on this topic. So I hope that sets up a really interesting discussion. First, I'd like to welcome Johan Ketelaar. He is a senior advisor at Oxira. He's an adjudicator for the Irish telecom regulator. He has over 20 years of experience as a regulator, including at the Dutch Authority for Competition and Markets. So he will bring both the regulator and the economic perspective to today's discussion. Next, we have Anna Colom, who is joining us virtually, and I hope you can hear us, Anna.
I can, I hope you too. Thank you.
Anna is a senior policy lead at the Data Tank and a visiting scholar at the Open University. And she is a political scientist who will help us explore what democratic legitimacy looks like in this sector. And then we will have Paula Cardozo Solano, who's my colleague and fellow researcher, PhD candidate, and lecturer at ALTI and VU Amsterdam, who's been looking into this topic for quite some time, and she will highlight where the design might fall short of a rights-based approach. And last but certainly not least, it's my pleasure to welcome Alberto Di Felice. He's a policy and legal counsel at Digital Europe, which is a trade association with over 45,000 members that are active or invest in Europe. And he will bring the industry perspective, and if you accept a little spoiler, also a healthy dose of realism to our discussion. So before I give the word to our speakers, which is what everyone's waiting for, I have two more things to say. The first is just a very brief background on the common data spaces, and the second is a bit about how the debate is structured today. So very briefly, the Common Data Spaces initiative traces back to 2020, when the European Commission released its communication on its strategy for data. And that essentially aimed to create a common market for data in Europe, a corollary to the Digital Single Market Initiative. And the hope was that this will increase the use and transfer of personal, industrial, and public sector data. And the initiative has two main pillars. One is a horizontal pillar, which includes initiatives like the Data Act and the Data Governance Act. And it sets cross-sectoral rules for accessing, using, and sharing data. And the second pillar is the common data spaces, which are specific domains where common data sharing rules will exist in sectors like healthcare, transport, energy, agriculture, and so on. There are over 10. The number keeps changing as more and more are added, so I'm not going to name all of them. But it's worth naming the European health data space because it is the most advanced. And actually, on 25 March, the regulation for that data space entered into force. So in theory, these data spaces are there to boost innovation, boost competitiveness, and increase the protection of fundamental rights. But as we will see from our panel, the reality is a bit more complex. So today we'll explore those complexities in 3 rounds. The first round will be a slightly longer round, and we will focus on the setup of the data spaces. And we'll ask questions like, are the goals aligned? Is the framework coherent? Do we have the right principles in place? And do we already see some challenges emerging? The second round will be a bit shorter, and we will discuss about how this initiative works in practice, and what will be the challenges that will face regulators, individuals, and businesses as we move towards this data space becoming a reality. And lastly, the third round is a round for all of you, so we will open the floor to questions, and we really look forward to that. So this was my little introduction, and without further ado, I think, Johan, I would like to start with you, if I may. And I'd like to start with the fact that the European Commission lists several problems that it's trying to solve with the common data spaces. On the one hand, it's trying to increase the data available that can be used for innovative applications, primarily by creating data pools or increasing data interoperability and data quality. On the other hand, the Commission also states that it's trying to address some market failures and some asymmetries that exist in market, particularly between big tech and SMEs. In that context, I'd like to ask you, because I know you've previously labeled yourself as a constructive skeptic, how do you view the goals and the coherence of the data spaces?
Thank you, Georgiana, and it's a pleasure to be here. I thought I'd seen everything in Brussels already, but this is a new dimension. It's a bit like a prison, but I like it. It's only waiting for the beer taps to go open, but it's a nice place to be here, and it's beautiful. And it's a great event, and compliments already with the organization. And it's super to be part of this panel. In your announcement, you said already that there would be like diverging views. Could be, maybe. I'm not so sure. There could also be like overlap. But I think what you rightfully concluded already is that this is like a very wide topic, right? And if you only look at the description and the title of this panel, it's about fundamental rights, it's about innovation, competition, it's about geopolitics, as we all know, it's about cybersecurity, it's about privacy. So all those aspects come together. And still we need to find something about it and do something with it. So I think it's very important to speak about it from different disciplines. The way I want to approach it is indeed, as you said in your introduction, a little bit from my regulatory background. At ACM, I've gone through all the technology cycles as a regulator, where in the beginning it was like relatively easy. I wouldn't say like very easy, but and the trade-offs were always about competition, innovation, investment, consumer protection. Then later only fundamental rights came into place. I think first with net neutrality as a key principle, and then also privacy and those kind of things. And now we find ourselves in this new world where data, algorithms, AI, everything is happening. I wouldn't say at the same moment, but if you just take like a couple of years back, it's like a wave, right? And then we've got all the legislative initiatives, some of them adopted a little bit earlier, but many of them only recently, and we are only facing the first round of enforcement, except maybe for the GDPR. So it's all very new, and like you said in the beginning, it's also very complex, and everything comes together, and there are also like effects where one piece of legislation or one particular enforcement action influences something else and could trigger also something different, which was not unexpected, right? So it's also a very delicate environment that we operate in. That is a sort of scene setter. I work for Oxera as an economist most of my time. I'm also, like you said, an adjudicator in Ireland, so a little bit of my former regulatory background is still active. I'm not representing any of the customers or a regulator here. I'm just speaking on my own behalf because I'm a huge fan of discussions about better regulation and about the complexity of EU regulation and politics. So that by way of intro. I think if you dive deeper into the data spaces initiative, I think it's impossible to see it isolated. It's also the way the European Commission presents it. It should be seen in coherence with all the other things that are happening, all the legislative proposals. I mentioned a few already, but like the Data Act, we've got, of course, a DMA, DSA, and Data Governance Act. That all is like one package, which is supposed to make the EU more competitive, more innovative, but also less dependent. So these are like big goals, right? And I've been a regulator, but I've also been around in the field over the last couple of years and picked up like signals and heard from stakeholders that this is, of course, people will speak from a particular interest, right? So quite often, of course, companies are complaining about the digital legislative patchwork. I think to some extent that is legitimate. But also, it's also a little bit easy because you need to dive a little bit deeper into the different effects of all those legislative initiatives. I think you mentioned the word coherence, I think, in your intro. It's also something I had written down. And the European Commission itself uses quite often now these days, after Draghi, simplicity. But I think coherence is like a more important term, to be honest. And I think it's important to be coherent, because we all know that if you have like particular provisions about interoperability, which are supposed to create like more contestability or competition, then there's always like a trade-off with like other goals, for instance, privacy. And then in the data spaces initiative, all those things also come together. Then me as an economist and as a, how did you call me again? Constructive skepticist, right? When I see like, not per se by the EU alone, but if I see like investment proposals by governments, I think I always have like, the first question is, like, what's the harm you try to solve, right? Or what's the opportunity you try to dip into, which is not tapped into by the market itself, right? And I can see that, and you mentioned health and agriculture and all those like different spaces where I can see that there's not a lot happening and there could be more happening. So it's good that the European Commission steps in with initiatives to try to generate like new use cases and to become less dependent. But I also think you need to be still critical and also not think that immediately this will lead to like big tech becoming less big, right? So to say, because I think I can think of scenarios where it could even make like big tech bigger. Not necessarily, but also not the opposite, right? I think that the ambition should be to be more independent and to be more to make more use of like innovative use cases. But I think to use it as a tool to break like big tech, I don't think that that's the first goal. There are also other laws aimed at those kind of things. You can always discuss how successful those are. So that's one thing. I think the other thing related to coherence is that I think there should be like a clear, and this goes not only for the data spaces initiative, but also for like legislation and the way enforcement takes place. There should be clear feedback loops, and there should be more like measurement about the effects, right? Not only for a particular goal. So take the Data Act, for instance, which is supposed to, just like the data spaces, to create more potential out of data that we all share with each other into like aftermarkets, other markets that are now non-existent. That in itself and on paper is like a beautiful goal, right? And nobody, maybe somebody, but not many people will say, hey, that's a very stupid thing to do. But then the effects of this law, how well intended on paper, in practice, might play out completely different. And then the simple fact that it's not very clear at the moment, and I'm only talking about the Data Act, but there are more laws, right? For players, and I'm not talking about US players, also big European players have openly expressed concerns about their interpretation of what it means. And as an economist, I also look at what does it mean in terms of incentives and in terms of like creating new products, if you bear in mind, in the back of your mind, that you need to share particular data. It could also have like an adverse effect for innovations, right? Also from European players. So coherence, clarity, feedback loops. And then the last point is about enforcement. I'm also fascinated by all those laws and the way they are enforced and have to be enforced, right? I think that many in this room know already that the European Commission is, I don't know, struggling, but they need a lot of people to enforce the DMA, DSA, and that's only, like I said, the beginning, and not even tapping into like all the interdependencies, which will only occur later, right? And I think that's something which should allow for feedback loops. I know that that's already happening within the DMA team, for instance, but I think we should be clear about goals, effective enforcement, and the very last point is about something which I always call like regulatory distraction, because in the digital space and in data markets, as an enforcer, and not only the European Commission, but also the national enforcers, whether it's like a Data Act, which will be enforced at the national level, AI Act, there's a lot of choice to be made by enforcers what you are going to prioritize, right? And I'm like an old-fashioned telecom regulator where it's relatively easy because the direct effects are clear and you have a clear threshold what you need to motivate before you intervene. But in the data and in the digital space, the degrees of freedom are much more. And you could also be played with a little bit by some of the actors by being, hence the word distracted, by being distracted in an area where it might be very comfortable for a particular company to comply and take all the resources of an enforcement agency and everybody looks happy, but in terms of what the effect is for consumers, for instance, that might be very limited.
Okay, thank you, Johan. And I think that's a very interesting perspective because what emerges, and I'm not going to summarize your entire contribution to that, but it's at least a picture of unclear and unforeseen or unintended consequences that might come about, at least when it comes to competition and innovation in the space. So there are already two of our keywords, and for our third keyword, I'd like to bring you in, Anna, if I may. I'd like, before I give the floor to you, just to very briefly introduce what the Commission says that its goals are, and I'm going to quote it specifically. So the Commission says that its vision stems from European values and fundamental rights, and the conviction that the human being is and should remain at the center. So Anna, with that in mind, I'd like to ask you, what is the role of fundamental rights in the common data spaces? And is there perhaps, as Johan perhaps hinted, a gap between the Commission's vision and the reality of the enforcement of the data spaces?
Okay. Thank you so much. I hope you can hear me well. No.
I think we need to hear you a bit louder if that's possible.
Let's see. Hello, hello. Maybe I get closer.
That's perfect.
Okay, great. Thank you so much. Thank you so much as well to you, the panel organizers and the conference organizers, for allowing me to join online. I was meant to be here in person, but I have a bit of a nasty flu, so it's good that I at least can connect online. If I don't make sense, I'll blame it on the flu as well. But yeah, so I work at the Data Tank, which is a non-profit based in Brussels, although I'm not, as you might imagine, that focuses on skills development, research, and policy on data reuse and data governance. And we do work also, especially on the space of data spaces and European common spaces as well. So I'll expand a bit on how the spaces relate to fundamental rights, but I also want to make clear from the start that they're linked to fundamental rights and to democracy, which I'll talk about as part of that, is also, to me, key to innovation and competitiveness. No? So, for anyone who's coming more from the point of view of innovation and competitiveness, I think I want to make it clear that for me, they are really intertwined and related. If we have spaces, platforms, technologies that work for some people but not others, or that can cause some harms or not protect the rights of everyone, then I think it's, there are spaces, technologies, and platforms that do not work, no? And therefore, that they are not, I don't see why they would be innovative or competitive if they don't, they are not here to help us solve social and planetary problems. So I wanted to really make clear this assumption that one might drag the other down, and again, state that data spaces can enable innovation and competitiveness because they have democracy and fundamental rights at its core and not in spite of it. That's at least my vision for that. So the case I want to make, I'll talk a bit about, I'll make the case for democratizing the data spaces, and maybe in reference also what you were saying now, the gaps that they might be at the moment in how they are being developed. I'll also speak about the European health data space a bit more, not only because it's possibly one of the most sensitive ones as it relates to health data, but also, as you mentioned, it's the one that's the most developed. It's already entered into force 2 months ago, and there's already standards and mechanisms for data sharing that are being developed at the moment. So why the case for democratizing the data spaces and really paying attention to the fundamental rights in them? So there's a few reasons. One is legitimacy. we know already that current binary and static approaches to consent are not sufficient because data is not only individual, but it's also collective and a relational good. And there's been concerns raised already that there's been limiting involvement by the public in the drafting of the EHDS, the European Health Data Space. I'll quote, for example, Stoughton et al., a paper from last year. They say a social license and public acceptance to access data for research, in that case, but the data is also meant to be accessed for other reasons, cannot be assumed simply by having a legal framework in place. So there's a lot more we need to do really for these spaces to work, to be legitimate. The second point for the case I want to make is integrity and quality of the data. Data reuse means that important metadata, such as information on the initial purpose and the context that a data point or a data set represents, can be lost when data is reused. And this has implications for the validity of the data and the safety as well of this data. Data travels, data changes, and its meaning changes over time. So we need to be careful throughout the data life cycle how we trace identify the context of the data and ensure its integrity, basically. Emerging and advanced technologies are still, unfortunately, relying a lot on opting out rather than ensuring explicit opt-in first, or do not use consent processes at all, as we've seen, for example, with general purpose AI systems, which have really challenged the boundaries of what was okay or not to do in terms of which data was okay to use or not. And then the third point I wanted to make is on operationalization, how you operationalize a data space, how do you make it useful? And there's a challenge with aligning meaningful participation with the scale of the European data spaces and the seamless traveling of the data across states and different constituencies. However, without meaningful participation of different publics, it's difficult to imagine that people can maintain their agency over data, that processes can account for this relationality of the data and for its collective impact, and that the integrity and the ground truth of data can be respected, and that people will trust these spaces if this cannot be guaranteed. So there has to be also alignment across entities, countries, and transnational constituencies for this to work. So what me and my colleague, Professor Marta Poblet at the Data Tank, proposed in a recent paper is that it's a multidimensional framework. Sometimes I feel we need to step back to think about, okay, so how do we ensure that these spaces are democratic, that they involve participation, that governance is really carefully thought through. And sometimes we felt highlighting the need for multidimensionality was important. We suggested a framework with at least 6 dimensions, but our point is that there might be other dimensions we need to consider depending on the context. But we propose in this framework to think about first the type and the meaning of data that we're dealing with, because there'll be differences in how governance structures should be put in place depending on the data. Then the type of the governance instrument. Are we talking about hard law, soft law, policy, principles? What type of governance instrument can we use? The scale as well of the setting in which participation applies. So the data spaces are, of course, EU-wide, but they involve states, but they also involve regions, nations, cities, rural areas, data cooperatives, data unions, different types of scales in which we need to think about how are these spaces governed. The fourth dimension we talk about is the models of democracy. So not thinking only about representative democracy and elections, and then everything else comes top down, but actually what do we have, what tools do we have to improve governance? How can we use deliberative democracy in this context and at different scales? How do we ensure that civil and political rights are protected, that civil society has a role to play and is empowered to play that role? The fifth dimension is the stage of the data reuse cycle. So really thinking about governance at different stages. Are we talking about the point in which data is shared / collected? Are we talking about analysis and processing? Are we talking about oversight and evaluation, etc.? And finally, but not the last one, as I said, we think this is an open framework and there might be other dimensions. It's who is participating. Because at the moment, for example, in the European health data space, the participation has been limited, but also at the moment, the institutions that seem are going to have the most responsibility in decision making is the health data access bodies, which are state level bodies. But how is everyone, different organizations, people, communities, institutions, other stakeholders within states and within nations and within regions going to play a role in the decision making on how data is used, how it's accessed, who should access it for what, who will be overseeing that process is beyond the standard institutions and top-down mechanisms. So I think I'll stop here, but I just wanted to offer a perspective in terms of what could be a gap, as you were saying, at the moment. We're paying a lot of attention to infrastructure and technology in these ecosystems, but I think less attention in how these ecosystems will be governed and how inclusion and participation will be meaningfully embedded.
Thank you, Anna. That's certainly a very interesting perspective, and also interesting to hear that fundamental rights are key, not just as a goal in themselves, but in order to facilitate or enable competition and innovation, which are arguably other goals of the framework. But also to see that some goals that we might not think initially are in conflict could be, like data reuse and data quality might be conflicting with each other, and that scale is needed for value, but it also raises risks for data, maybe even data quality. And that we need more thought and perhaps more granularity than is already out there in the framework along these 6 dimensions, or possibly even more. So there are already several things that we need to consider for the data space. And Paula, I'd like to go to you next, because I'm wondering if there are additional risks that are hidden or that are emerging that we should be discussing.
Yeah, thank you for the question. I definitely consider that it's important to discuss the European Health Data Spaces policy, because this initiative will certainly have a transformative impact in the strategic sectors that the European Commission has defined. However, I would like to say that this discussion shouldn't be framed exclusively in terms of data protection or competitiveness or innovation, because we would be missing some other important questions. For example, who's getting advantages to access the data, whose interests are prevailing in how this initiative is being framed, but also who is going to extract most of the benefits derived from this initiative, but more importantly, are these benefits actually aligned with the common good? So, as you know, the European Commission has placed a data-driven innovation at its center for its vision for Europe's future. However, there are some emerging tensions that are arising between collective welfare, particular gain, interests of the collective groups, fundamental rights, and corporate influence. So I think to answer to your question, I would like to discuss 2 groups of emerging risks that come from this dominance of the digital in the narrative that is guiding Europe's future. So first is the risk of expansionism of big tech, as well as of entrenchment of the position of the incumbents in specific sectors. And then I would like to discuss if there are enough legal safeguards in place for both individuals and societal groups. So, concerning the first part, over the last decade, we have seen how big tech has expanded its power over its original influence from the sphere that we may call the digital to other spheres, for example, education, the law, agriculture, health, or even sectors that we didn't realize at first that they were going to be relevant, for example, oil and gas. And this could be the case of what some scholars have framed as the framework of spheres transgression. I would refer to the work mostly of Tamar Sharon. And a sphere transgression is a situation when there's a transfer from power or a certain advantage from one actor that pertains to a certain sphere. In this case, we would refer to the big tech as pertaining to the sphere of the digital, right? And how are they gaining advantages in sectors like the ones that I mentioned before? But of course, gaining influence is not necessarily bad. However, there is a risk that they are redescribing the way that these sectors operate and undermining the values and the principles of justice that are intrinsic to these spheres. So landing these to the common European data spaces, I consider that this initiative may strengthen the possibility of a sphere transgression occurring, because first, data is considered now a cross-cutting consideration across the most important sectors for Europe. Second, sectors are designed or are projected to be data-driven, and they are measured by their capacity to create, share, and process data. And this data, it's going to be used for create insights that are going to, at the end, generate economic value. So I think that is the risks that societal spheres that had, as I mentioned, different values, different considerations, are going to be considered as data markets. So the role of big tech then, it's not only to provide support for this initiative to be a reality, but I think that there may be a risk of these companies redefining the agenda or the purposes or the directions of these industries, considering their own interests, their own priorities, and their own values. This, in addition to this, this initiative may also entrench, paradoxically, dependencies to big tech, to this infrastructure and services that they provide to make this huge initiative a reality. But on a second point, I think that it's also likely that this initiative, if it's not, if it's not guided by achieving the common good, we may have a scenario in which we are cementing the influence of long-standing sectoral incumbents in those strategic sectors. And I think that special care should be given to those sectors that have oligopolic power, sorry, because these actors would be in a best position to get advantage of more data that is going to be made available. So it's important then that the welfare of the interests and the fundamental rights are actually guiding considerations in the deployment of these data spaces. So to mention the two cases that I think are a bit concerning, what about if these initiatives are actually entrenching the power of big pharma or the well-known firms in the agriculture sector, right? And then, I would like to mention then that from this scenario that I just have presented, I think that the GDPR doesn't appear as the solid framework, a solid framework for digital trust, which are the words by the European Commission, to point out how relevant is the GDPR for safeguarding the rights of individuals. And I think that there's so much more that need to be done, and I agree with Anna was saying previously of how important is the governance that these data spaces are going to have. So at the end, it's not only about legal compliance, because I think that these spaces are going to be deployed in a GDPR compliant manner. But it's about how we actually are going to safeguard autonomy, sovereignty, and fairness of individuals, and not only individuals, but also about the societal spheres.
Thank you, Paola. That's certainly an interesting contribution, and it was interesting to see that, as Anna mentioned, we need scale, but what you mentioned is that actually the participation of certain players or certain kinds of players might be problematic, whereas we might actually need those players to provide the majority of the data and the data spaces. And I think what I can also see through the lines in your speech is that we are focusing so much on fair distribution, on fair access of data, but perhaps we should also be thinking about fair distribution of the benefits that result from the data spaces. And I think, Alberto, this is the perfect time to bring you in, because as I said at the beginning, you represent the industry, and you are particularly representative of Digital Europe, and your organization actually represents both big and small players. So you have some members who some might describe as big tech, and you also have members who are described as small and medium enterprises. And these are the two groups that the Commission often portrays as perhaps being in conflict with each other, where the common data spaces should favor one while not entrenching the other. So I want to give the floor to you and to ask what's the industry perspective for after everything you've heard.
Wonderful. Thanks a lot, Georgiana. Very, very interesting panel. First of all, before I go into my spiel, just so I understand, how many in the audience have 90% reassurance that they know for sure what a data space is? Hands up? That's a lot of people. Damn. Okay, it's a difficult audience. Okay, so the whole debate about data spaces so far, I would fundamentally challenge this opposition between big tech and smaller companies, because I think big tech actually in the whole data sharing discussions that have happened in the past 5 years in Europe have been a relatively distant player. The main two proposals, with the addition, of course, of the European health data space, which I will park for the moment because it has specific challenges. But the two main proposals have been the Data Governance Act, which is about public sector data and reusing it. The other one has been the Data Act, which has a number of sub-proposals within it. One is the cloud chapter, which you could argue is about big tech because main cloud providers are big companies. But the part, so it is related to the data space discussion, but the main discussion has been about data sharing. So data sharing from connected devices. And actually the people from an industry perspective who have been more targeted and concerned about how this is going to play out have actually been traditional hardware manufacturers from across a number of industry verticals. And most of them are not, certainly not exclusively non-European. Most of them are big European manufacturers. I'm not going to mention names, but you can go on our website and you'll see a list of them directly in the direct corporate chamber. And as you were kind enough to remind the audience, we also have another indirect chamber of members that are smaller companies, largely that are represented by our national trade associations. These are largely national companies that, for the most part, would meet the new definition of mid-caps that everybody got so excited about. 750 employees, slightly more, slightly less. And it's not been a discussion about fundamental rights at all, because the premise of why the European Commission has been doing this is that, we lost the battle on consumer services that are largely dominated by the Americans' use of Europeans' personal data, and now we're going to focus on industrial use cases. We're going to free up the power of non-personal data. So the whole edifice is based on the fact that non-personal data from connected devices will be made available to users, be they consumers, individuals, or business-to-business users of those devices. And for a long time in the legislative discussion, we have lived in this parallel universe where we were only talking about non-personal data, even though in the regulation there's quite a lot of references to personal data. And the relationship has been articulated fairly naively, but it's fairly straightforward as well, meaning that we have the Data Act, you have obligations on the Data Act. Whenever personal data is involved, the Data Act applies and the GDPR applies. So we're all good. They're all without prejudice to one another, which is a wonderful sense of harmony. So the main problem from an industry perspective that maybe I want to articulate is that this has all been very speculative. So this narrative of the need to force companies to share data is based on an assumption that we have a number of markets where these devices are deployed, where there's market failure everywhere. And the fact that there's market failure is simply evidenced by the fact that there's not enough data sharing. And therefore, we must force people to share data. And a good way to do that is, of course, to have a regulation that says you will share data, and in addition, you will list 127,000 rules, I'm exaggerating, that companies will have to abide by if they want to share data, when they do share data. So it's a very complex system. If you open the Data Act and you put it next to the GDPR in printed A4 paper, it's about 4 times as much. There's articles of the Data Act. There are, if you have the official journal of the EU before you, they stretch over 3 or 4 pages of the official journal. There's 15 paragraphs in a single article, and they're not small paragraphs. And it's very difficult to figure out what they say. We had discussions with the European Commission early on about trying to interpret early on what those provisions say, and we keep having them, and the bottom line is that we don't know, nobody knows, and we'll have to see what happens. From an industrial policy perspective, we've been very concerned because, again, all these assumptions about market failure, if you think about it, really, this is some form of competition enforcement. Okay, there's this assumption that data is not being shared, and therefore you're assuming that each individual manufacturer is dominant in its position, and a very drastic but classical theoretical competition law remedy would be to force them to share data. And that's completely unproven. I like to go back, as you know, the Commission needs to do impact assessments for all their proposals. They commission studies of consultancies, and you can go and read the studies on the Data Act, and they are, the people who had to write those for the Commission are actually pretty open that we interviewed a good number of people, around 20 people. Some of them see benefits and maybe see a business model around this, but the data that we have is not solid enough. It's all relatively anecdotal. So we cannot draw definitive conclusions about this. This is black and white. I'm paraphrasing a little, but it is precisely what the consultant said. And yet we had a full legislative proposal, that's 4 times the GDPR, about this. And the dangers of doing this without solid market evidence are manifold. As I said, from an industrial policy perspective, the people who stand to lose from this are largely European manufacturers, the people that Europe is counting on to be the next leader in a lot of industrial use cases, taking our industrial leadership that we've had so far into the next phase of digitized businesses. And right now, before they have had time to actually figure out exactly what their business models are going to be, they already have to comply and are restricted from doing things. One basic thing, for example, is that you as a company cannot decide to share data exclusively with one commercial partner because you need to provide access on equal terms to everybody who asks. And that's a pretty strong thing to want of a company before we know that they're actually doing something wrong. So this is a big assumption behind the system. Right now, we're dealing largely with these general frameworks. The Data Act is a general framework about devices. The assumption is that it will be replicated for other data spaces where we don't necessarily have firm legislative proposals yet. But the system, we already see quite a lot of strain on the system, quite a lot of need to make sure that we not only understand the intricacies of the interplays of legislation and the GDPR, and I could give you examples, maybe in Q&A you can ask me, but also most importantly that we don't get this wrong. It would be pretty self-defeating to have regulation that's supposed to make Europe stronger industrially and that ultimately targets the European players who are supposed to do it.
Thank you, and that would indeed be quite unfortunate, but it might also be where we're heading if I draw some insights from everybody's contribution. So some of the things that you said that I think are going to launch us into the second round that I found very interesting was the speculative nature of the assumptions that went into making the data spaces or the Data Governance Act, and in particular this assumption about there being market failure, assumption of dominance, and assumption that the proper remedy for the problem is data access. if I may paraphrase your position. And that's where I think, Johan, it would be interesting to hear your perspective as an economist and as a regulator, whether you see a mismatch between how the Commission views the market, or the view that went into the impact assessment for this regulation, for this initiative. And the reality is that enforcers are actually going to be faced with once they start applying the rules and being there on the ground and in communication with companies. And I think one thing that came full circle is you started with coherence instead of simplicity, and we ended with more simplicity is needed in some ways for the long pages of the initiative.
Thanks, Georgiana. Yeah. Quite a lot has been said after me, which is very interesting and triggered my thoughts, which went in many directions. But let's go back to your question. And I don't think there's like a direct mismatch with the goals by the legislators. That would go too far. And I understand the arguments that Alberto brings in because to a large extent, these are also like economic arguments. And I mentioned earlier already that I thought it was important to have like not just like if you look at impact assessment of one particular piece of law, but also at the interplay between laws, which is in a way undoable almost. I realize that, but it's good to have that broader perspective in mind, which is also why I mentioned in my first intervention the need for feedback loops, right? Because, and this you might call a mismatch, but I think I would rather call it like a reality check, because those laws, if you take the Data Act, which is now mentioned a couple of times, but also the broader ideas behind the data spaces, on paper it looks nice, right? I said it already, it looks like noble. We want to be less dependent. We want to create value out of the data which are there, which we can use, right? And I also agree with what Paula and Anna said about fundamental rights need to be guaranteed, and I also agree with Anna's observation that fundamental rights are not necessarily a roadblock for competition and innovation. I think it's like the guardrails, as long as we have like clarity, and as long as we also know that, I think it's also important to know what fundamental rights are. We can talk about that in a second maybe. So I wouldn't call it like a mismatch, but more like feedback loops. And well, the text on paper might look like from an idealistic point of view good, and the goals, right? The Commission always says like this, the goal of this particular act. And I remember this, I had a discussion with somebody in the European Commission who's responsible for the Data Act about the goal of the Data Act. Because I brought in contestability and competition in a particular discussion where I was participating. And the European Commission was very firm, like, no, this is not about competition, this is like about fundamental rights. The Data Act is about fundamental rights. It's about consumer empowerment. And so I think that you can say that, but the effect of the Data Act is, of course, way more than just about empowering consumers or creating like a new market. And I think Alberto mentioned a couple of things. So even though a goal of a particular law might be privacy, data sharing, contestability, right? Because also there's a difference between contestability in the Brussels lingo, contestability and competition, right? But even though you might frame it in a particular way, the effect will be broader than just that particular goal. And I think that aspect needs to be realized, and I'm sure that people realize it. But that also should be brought in like what I call feedback loops, but also like even if a particular impact assessment has illustrated already something, the reality needs to allow for like mechanisms to measure the effects and to adjust. And I think in the DMA is a good example where the Commission is quite open about the way they enforce, and that they say that this is like an iterative process. We are sitting together with the gatekeepers, and some people might argue that that's not the way it should be. But I think reality is that it has to be this way, because this is not like I said it earlier, this is not like an easy market with like 2 dimensions. It's got so many aspects, so many facets that need to be taken into account. So that brings the obligation to have that multifaceted approach also when it comes to impact and much more, right? Like enforcement, what I just said, and priorities. Then maybe one last point in this round is about fundamental rights. What is a fundamental right, right? Because I personally care a lot about fundamental rights, whether it's privacy, freedom of speech, online safety. But data sharing, you can argue, right? GDPR is for me important, and privacy, of course, it's not perfect, but I think as a concept it's important. But I think that with some laws, especially when it comes to data sharing, there's like a tipping point where fundamental rights tip a little bit too much into some kind of idealistic goal that data sharing will lead to all kind of beautiful things. But I think data sharing can, there's tension with privacy, but there's also tension potentially with competition. Data sharing could lead to more entrenched positions. It's not a nice message to share because many people believe always like interoperability, all those terms, interoperability, neutrality, everybody thinks, oh, that's perfect, that's good, that's like, but it's not always the case. The actual effect could be even adverse. So that's another argument to keep watching closely what actually happens. And then the very last point is about geopolitics, because I understand the sentiment, right, that, hey, we are creating these data spaces and we want the European players to grow and make use of it. I'm not like I read politics, but I'm not like very political myself in that sense. I look at it like in a little bit more like down-to-earth way. I think you shouldn't start by excluding particular players from tapping into it. Alberto said already, like the big tech is a little bit further away from those data spaces. I tend to agree with that sentiment. Maybe in practice at some point it will change, but I think in first instance I don't see a clear link between big tech, entrenchment, and the data spaces. And I think I know that you were not hinting on this, by the way, but any suggestion about excluding particular players because we don't like the color of their eyes or something wouldn't be good. I think there are other rules. If you've got the fundamental rights in place, then you should assume that Europe will benefit from whatever innovation is triggered by the data spaces.
Thank you. So it's very interesting to see that we have noble goals, but we need more than noble goals. Maybe more feedback loops, as you said, more acknowledgement of the complexity of the market. And also interesting that you mentioned what is a fundamental right, and that might be a question to everyone. Are we on the path of free movement of data becoming a fifth fundamental right along the other four free movements that are enshrined in the treaties? And I think, Alberto, I'd like to go back to you, if I may, before I go further towards Paola and then Anna, because I think it would be nice to see your perspective after all of this. You're closest to the industry, and I'm curious what effect, because the effects are so uncertain and there's potential for knock-on effects, what actual impact do you think is going to be on industry members, on members of Digital Europe? And in particular, is there going to be, as I think you hinted in your speech, an effect on their freedom to choose their business models, the freedom to choose their contracting partners, or the freedom to leverage the competitive advantages that they fought so hard to create?
Yeah. Oh, thanks. So, yeah, indeed, absolutely. So I'll just refer to the Data Act because I think it's the one that has preoccupied us the most. We've also worked on the European health data space, which is very interesting, particularly what you said about other big players that are not big tech. But again, I'll park that. So indeed, we are worried about the fact that, no matter what, no matter if and how successful the actual framework will be, because it's effectively based on a market emerging of people who want to ask for data and use it, companies will already have to comply. So from the moment that you put a product on the market, you will have to redesign it so that from the get-go, as much data as possible is made available to the user directly. You have to put in place a relatively arcane system of contracts that you need to have ready with third parties that may want to access the data. So this is on top of all the contracts you already have in place. They do intersect with the data protection elements of those contracts as well, and that only adds at this point in time to, again, the administrative burden that companies have. And then obviously, as you said, and as I said already, I mean, this, companies are by law forbidden from engaging in any type of preferential business model that's related to data sharing, because there's only one way to share data for them going forward, and that's based on the rules from the Data Act. So this is a fundamental impingement on their freedom to figure out, frankly, how they're going to make their money, and what part of the ecosystem they're gonna sit in, and their providers, et cetera. So these are pretty real concerns that will be materializing in the next couple of years. I think right now, obviously, we're excited to see. I talked about complexity a lot, but there's an effort going on, and the announcement today on the omnibus on the GDPR is an example of that. But there is consideration from the Commission about what parts of the new laws that we have in place could be looked at and potentially simplified. We do have our ideas about that, which I will not go into. But again, it's not all bad in the sense that we still have time to realize what works, what doesn't work. Some of those problems, particularly around the authorities that are involved, the plethora of authorities, which is a very real concern that companies will have, for example. Those things we can still fix because we have a window of roughly 2 years where companies will start compliance and they will spend a lot of money on it, but they can still be protected for some of the unwanted consequences, as we say, around the commercial and industrial dangers.
That's certainly interesting, and also to hear about what might be a high cost of compliance, and also a bit of optimism that there's still time to fix any problems that we see. And you very strategically parked the European health data space twice. So I think I'm going to ask Paula to do the opposite and to bring it back, because you've also, Paula, looked at the European health data space, and it may be a bit late to fix that, or it may be more difficult because that's already up and running. So what challenges or what lessons do you think we can learn from the European health data space that will help us fix the other spaces, or help us figure out how to create those without running into the same issues?
Yeah, well, first I would like to say that after the COVID-19 pandemic, it was clear that there's a need to manage health data as a shared resource, and it is fundamental for making faster the development of medicines, vaccines, for improving diagnosis that is going to be powered with AI, and in general to improve health research. However, I think that the regulation of the European health data space has raised many concerns, and particularly in legal, ethical, and governance aspects that I would like to refer to that. So first, the one that has been mentioned more extensively is the change of the consent model from an opt-in that has been traditional in how we manage the data that is related to our health and our bodies, right? And now we're going to have an opt-out model. And as we know, the power of defaults is really strong in how we take decisions. So we should expect that people are not going to opt out the system. So their data is going to be shared for secondary use by default. And secondary use is the use of that data for uses beyond the provision of healthcare. I think that it not only hinders the rights of patients as data subjects, or the rights derived from the GDPR, but also it harms our individual autonomy to decide how our most intimate and sensitive data is going to be processed. And related to that, I find particularly concerning the definition of a health data user, and also the definition of the purposes for the processing of secondary data, which I think are extremely broad. And the problem is that the health sphere, what I was referring initially, and that has values such as care or trust, is being eroded and it's being challenged, because as I mentioned, this extremely sensitive, intimate data is going to be available for actors that are not part of the healthcare sector, that are not involved into medical research, don't have the same expertise, they don't have the same professional duties, and that takes us to, and they also have different motivations, different principles, and different values that guide their interests. So this equates commercial purposes with traditional health medical research that has a clear, that has been clearly oriented to the public good, whereas here this is not that clear. And I think that this, as I mentioned, this opens the door for companies such as tech companies or companies from completely different sectors to get access to this information. And then as also Anna was mentioning, I think that the role of the health data access bodies that are the ones that are going to grant the permits for accessing this kind of information is going to be fundamental. They have the big role of ensuring that this is actually going to be that these permits are going to be granted to ensure the common good or the benefits of the patients. And I think that it's important that this body, probably repeating a bit of what Anna was saying, is, at some point this includes the participation of different stakeholders, such as the patients, but also the healthcare professionals, and considers their points of view. And important also that how the task that these bodies are going to have is going to be compatible with the GDPR and with the activity of the data protection authorities, but also with the bodies that are in charge of the ethical guidelines for medical practitioners. And this takes us to another point, that is medical confidentiality, which, even though it's not an absolute consideration, it's going to have this data sharing in this field as an exception. And it's important to see if this is not going to erode at the long term the trust that patients have in the medical practitioners, even particularly when the public health purposes are unclear. And I think in some, these are the aspects that should be considered for the upcoming data spaces. So actually not only, protecting not only the individuals, but also the particular considerations. And that's something that I liked about how this initiative has been framed, that allows for considering the particularities of each one of the sectors, because they are pretty different, like what you were mentioning also, that's not only about personal data, but also non-personal data, but that doesn't mean that it's related to the very core of each one of these sectors.
Thank you. So it's very interesting to see that some of the criticisms are about the horizontal initiatives, whereas we might be a bit more optimistic about the sectoral data spaces. And also very interesting to see that we started with a European healthcare data space, which might be the most sensitive at all, because as you, Alberto, mentioned, it concerns personal data, not non-personal data. So we chose to start, and if it works in this sector, we might infer that it works everywhere else, but it might not work yet in this sector either. And Anna, I haven't forgotten about you, but I kept you for last because I want to ask you a forward-looking question, if we can have you back. And I want to build on Johan's point about the current geopolitical climate in which we are, and the fact that this initiative from the Commission can be seen as part of a broader bid to strengthen its global competitiveness, to reposition its industrial policy. And I was wondering, in this context, where do the Common Data Spaces initiative fit in Europe's digital sovereignty?
Mm-hmm. Thank you, and sorry I dropped for a moment due to connection, but I'm back. So maybe to first step back in terms of why we're at this moment in time where Europe is really trying to find its feet and redefine its sovereignty in the current geopolitical context. I think it's good to remember, the reasons where we are and where we don't want to go back to. One is a huge power imbalance problem, and I'm talking in the world internationally. At the moment, not yet related to the data spaces, especially with big tech-led power concentration at scale. No? And that's an obvious problem for rights and democracy. It has implications for questions around data, like who holds the data, what is it used for, who is deciding that. We also have a narrative problem in terms of still really being quite driven by technological determinism, or this view that technology will solve problems. We can see this very clearly with AI and the narratives around AI, for example. And it has implications for questions like, what do we know about data? What value does it have and for whom? Who do we think, how do we think it should be used, and who should decide? And then a third problem is that we can see in the world and the geopolitics today is huge threats to democratic resilience, affecting different levels of institutions, in terms of the integrity of the information ecosystem, our social connections, our self and our collective self-determination. And again, this has implications for, who are we trusting about data, how are decisions made or how are they contested, how do we collaborate, who is represented by this data, and what is it that we believe to be true or not, etc. And a fourth point, which I think is very important, is the planetary resilience. And that relates to the Green Deal data space, but not only. All sorts of data are related also to our environmental and climate situation at the moment. So this has implications for the type of infrastructures and technologies we want to build, and for how these infrastructures and these ecosystems are helping us or not to unlock existing data. So based on that, I think overall, looking forward, we need to reclaim our agency, collective agency, our capacity to envision what society we want to live in and how we want data to be governed and used. We need to protect and build resilient democracies, and I know the EU has, it's now under consultation, a new democracy shield. And we need to build collaborative ecosystems of transparent, accountable, and inclusive processes, and the data spaces could be part of that. But we need, again, not to repeat similar mistakes to the ones that have led us to where we are. So as I said before, I think when we think about these data spaces and how we govern our digital policy, our digital industrial policy, we need to embrace the ecosystem logic for real. And that requires collaborating, not looking at the incentives of stakeholders individually, but how do we need to come together? How do we need to steward data? And how do we reuse it responsibly, making sure that everyone and the right stakeholders and publics are involved in that. We need to decentralize governance, as I said, as well as we're trying to decentralize infrastructure. So I think looking forward, we need to think beyond the state and think about how do we make the most of our democratic tools and the vibrancy of cities and regions and many areas in Europe so that they can have agency and be empowered to be part of the decisions around these data spaces. And we need to figure out actually how we sustain these data spaces. I think we are still looking for business models that work and that are value-led. Again, governance models for these ecosystems and spaces that are more participatory. And I think we also need new licensing tools that can protect the social impact and put it at the core of products. I think we're at the moment where IP is not working, open access is not completely working. We need some sort of data commons and licenses to make them operable. And finally, I think we need more knowledge and case studies from use cases. I think we're still talking a lot in abstract terms. It's very difficult for people to really understand how this relates to their lives and how they may have a meaningful say on data or the value it may have for them. So I think we need to make the data spaces more tangible and more relevant. Yeah, I think I'll stop here.
Thank you so much. So I think to sort of sum up, we need, as you said, more knowledge, more granularity. We need more feedback loops. We need more simplicity. We need more consideration of consequences. So we need more about these initiatives that are already rolling than they're already out the gate. And I think this brings us to the third round, which is open questions from you, the audience. The way this works is if you can, please walk to the microphone, because then your question will also be recorded and it will also be heard by Anna. If you cannot, I will try to repeat your question as best as I can. And if we may ask you to just, for transparency, please state your name and your affiliation, as that might be relevant for the question you're asking, and keep it brief and respectful. So please go ahead. I know those were a lot of instructions, but they were not meant to deter you in any way.
We will not tell you that your affiliation disqualifies you. I promise.
Hi, I'm Manuel Dominguez. I'm a DPO at Erasmus University in Rotterdam. I am in discussion with many data holders, and they are somewhat reluctant to the tasks that they have to share the inventory of their collections, the maintenance of this additional administrative burden, and the cost that they can, the financial, I don't, you know what I'm trying to say. So the revenues that they can get for this, will that be enough, or will they have to make difficult choices in closing important data sets? This is a real concern for some.
So to paraphrase, companies will not innovate if there's nothing at stake for them as well. So there need to be some incentives.
Yeah, I mean for the data holders.
Yeah.
So the data collections that would provide the data to the ARDS.
Would anyone like to respond? Yeah.
Yeah, no, that's an interesting observation in the sense that I'm sure there are I have some in my membership, but companies are going around and they're doing all the things that they need to do, product design, contracts, they need to update their terms of service with individual consumers, contracts, B2B contracts to reflect and map the data using from users, et cetera. And in most cases, people are looking around and they're like, but no one came up to me and asked me for anything. Why am I supposed to do all this stuff? So I have no reason to do this. So there is, huge, question mark in the first place. Like, why are we doing this? And I actually very much agree with Anna. Some of the final things she said. I mean, a lot of these problems that we are addressing through hard requirements on companies are actually problems about business development, figuring out whether companies have an interest in actually sharing data. And I can assure you that there's a lot of companies that don't see that value now. But the solution is not to force them to share data. It is to provide a path. It can be public funding. It can be a joint public-private partnerships, projects between different member states, et cetera. But that sells the value of doing it, that shows what the ecosystem is and what the value for them and for the people using the data would be.
Thank you. Please go ahead. I think we have 2 more questions lined up.
Thank you. Elisabeth Steindl, Ludwig Boltzmann Institute, Digital Health and Patient Safety. My question obviously goes to the European health data space, although it was parked a few times today. It is still the most advanced one, and we do have the regulation now. I'd like to draw upon something that our moderator said, that we started with the most difficult, most sensitive data space out of all the ones that we could have chosen. My question, the more I read the regulation and the more I talk about it with people, the more I see, the more I have increasing doubts that the regulation will actually deliver what we started out to implement. Because I acknowledge, I think everybody after the experience of the pandemic can see why it was necessary to have more harmonized rules for data sharing for health data within or across borders. I think there is a consensus on that. But the more you read the regulation, the more you see the opening clauses in the EHDS. And I'm asking myself if actually the regulation will not result in a more fragmented regulatory framework than we already have. We already have such a fragmented framework with the GDPR and the exemption for genetic data and biometric data and health data in particular to impose stricter rules than we already have for special category data. And we have very many of these opening clauses in the EHDS, and I'm just pointing out the most obvious one, which concerns the opt-out mechanisms, especially for secondary use, which basically allows to have 27 different mechanisms for opt-out. And so the question to the panel is, is my concern unnecessary, or do you share my concern that it might lead to a very fragmented situation? Yeah, so I think I'll leave you with that. Thank you.
Do you want to take it, Johan? I think Alberto already shook his head.
I'm not a specialist in the health care data space, but of course I can more generally relate to your concern, which is also a little bit what you in your question asked about. First having like a law or an initiative like the EU data space, and then seeing how that works out in practice, right? So you called it a mismatch. No, I wouldn't call it like a mismatch, but like the actual effects of a particular initiative, which again on paper is supposed to bring like a lot of value, but then in practice creates at a minimum questions, but potentially also like adverse effects even. And I think your question was related to the Data Act. Your is about data spaces. I think what's key, and this is me again as a former regulator speaking, is the regulatory dialogue, right? I'm not the European Commission. I'm not the actual enforcer of all the things we speak about. I know the European Commission is very busy enforcing laws, but I think when you have the Data Act, for instance, or also this initiative, there should be like a proper channel to speak about this, or there should be, and maybe there is, right? Maybe I'm missing something, and you might know better, but I think that mechanism, and it's also a little bit linked to what I said earlier with the feedback loops. It's like almost like a real-time feedback loop to have like a conversation about actual effects of a law or actual effects of proposed enforcement, like with the Data Act, but it's absolutely key.
Yeah. No, so the health data space is absolutely fascinating because it can hardly get more complicated. There's public data, private data, and there's a whole, again, ecosystem of complexity in the administration of healthcare in the member states. And so we went into it with a lot of enthusiasm, but you're, I think, absolutely right. I mean, a lot of the enthusiasm about opt-out being there was that we had legitimate problems to solve with how data was available for research, which, by the way, is one of the very few areas in the GDPR which the GDPR explicitly says should be interpreted extensively, broad interpretation of what research means, public and private research. So it's a good step to get there, but again, it's one of those examples. I don't know how long the HDS is, but I'm pretty sure you can find those examples of 3 pages of the official journal worth of an article. And of course, and this applies to a lot of the problems with our own sovereignty and how we build it in Europe. We're not facing the problem that without fundamentally addressing the fact that a lot of the stuff that we want to do still relies in member states, and we don't have clear tools at present. We need to build those tools to do things a bit more together. Call it variable geometry, geography, call it whatever you want. But we need to get past the fact that we still have to deal with national differences that we want to have. Some of those you can call them fundamental rights, maybe not to data protection. You can call them fundamental rights to healthcare, because healthcare relies on the financing of healthcare that happens nationally. But if we want to move to the next step and be more sovereign, again, the question will always be, what's next? We cannot continue to write laws and simply have, clauses that allow member states to do whatever they want, because we're simply delaying the problem over again.
Thank you. I think we're a bit overboard with time, so we'll have to wrap it up here. There might be questions that we didn't take, but for that, I'd suggest that maybe a conversation in the hallway would be great, and some of our panelists might be open to staying a bit after to answer some questions in person. Thank you so much for joining us. Thank you for listening to us.